Just like the United States, the countries of Canada, Australia, and New Zealand all have a common law legal tradition and large Indigenous populations. However, unlike the United States, Canada, Australia, and New Zealand are still part of the British Commonwealth. Let's take a brief look at the legal rights of Indigenous communities in these Commonwealth countries. The history of relations between the Canadian government and Indigenous populations is similar to that between early Americans and Indian tribes. In 1876, Canada passed the Indian Act. This act defined how the government would interact with Native Canadian populations, now commonly referred to as First Nations. Under this act, Canadian provinces could abrogate or repeal treaties that the government had made with Indigenous communities, often referred to as bans in Canadian law. In 1982, Canada amended its constitution to affirm the rights of Indigenous populations and the authority of Indigenous treaties. Section 35 of the 1982 Constitution Act holds that Indigenous nations would be viewed as partners in the Canadian government.